Hello everyone, thank you so much for joining me again for this newest episode of A Lesson in Real Estate. I'm Kate Thompson, a real estate professional and entrepreneur, and I just thought I would take a quick moment to share with you that it has been such a pleasure being able to bring this information regarding real estate to you. And I hope that for those of you out there who are in the market to either buy or sell a home, that for whatever reason you may have for doing either of those, that you are finding this information to be helpful, interesting, and insightful along the way. If there are any specific topics that you would like for me to cover in any future or subsequent episodes, I encourage you to reach out to me, and I will be happy to cover as many of those topics as I can throughout the course of this particular episode and all previous episodes. There is a contact phone number listed so that you could be able to reach out to me directly. I am going to continue that trend of having my contact information displayed throughout the program, and then at the end of this particular episode I will put the information up a little bit bigger so that you know how to either contact me via phone or text message or to be able to email me. And again, it is specifically to answer any questions that you may have regarding a specific real estate transaction that you're hoping to get involved with. I will strongly encourage you that if you are working with another real estate professional, that you give them the opportunity to answer your questions honestly and ethically, as I'm very confident that my colleagues can do that. But if you are in the throes of just beginning your process to either buy or sell a home and you have questions, or if you're just looking to learn more about the real estate industry and how the buying and selling of it works, please feel free to use the contact information that I put up. I'll be happy to cover any topics that you deem worthy for this particular show. So, because we have so much activity going on in our real estate market now, that's both local to where I am and on a national level, it's been very, very unusual, I would say, so much so that we have a lot of news articles and press being brought about in relation to this topic, real estate, and there's lots of things happening on so many fronts that make this market one that is very, very, very unusual. I've said in previous episodes, and I'll say right now, this particular situation that we find ourselves in this country as it relates to housing inventory is one that is so unique that we haven't seen anything similar to it since 1982. And that's just, based on sheer numbers from tracking this data. And when I'm saying the situation is very unique and it's been that way, and it hasn't been that way since 1982, what I mean is the inventory levels are extremely low. So I thought that today I would take a little bit of time and share with you some information that we're not really hearing a lot about. I could easily talk to you about inventory and things that you can do to navigate that difficulty, and maybe I will do that in a subsequent episode. But one of the things that I don't think we think a lot about when we're purchasing a home or when we're selling a home is what type of property deed we're going to receive. And lots of us really focus on what type of financing we're going to have. Most of us don't spend a lot of time worrying about who our realtor is unless they do something really bad. And that's the same for other professionals in our industry as well, whether it be home inspectors, whether it be, closing attorneys, surveyors, things of that nature. We're really just looking for the best price and trying to figure out a way that we can make the best deal for ourselves. And sometimes we can make a great deal as far as monetary, the monetary aspect of it, and do so up front, thinking that we're, getting a great piece of property and we're paying our money for it and there's no strings attached. And then somewhere along the line we figure out through, you know, whatever channels, whether it be a channel for you wanting to, you know, sell a home after you fixed it up, and, you know, maybe you decided to do a fix and flip. Maybe you lived in the property and just didn't think about any liens or anything being added to your home for, you know, different fees that you may have incurred over the years. You know, there are different things that can happen that can cause you to have some trouble when you're getting ready to sell your home. So I thought we would discuss property deeds today, and I'm going to share a little bit of information with you about that. As you know, I'm always interested in giving you great information, and I want to make sure that you're getting information that you can go and look up yourself. So as I stated before, one of my favorite websites is Investopedia.com, and I've gone there again today to get the definitions for the different types of deeds that you may see pop up as options for you to take advantage of in your real estate transaction. So first, I'd like to start by sharing with you exactly, you know, what a property deed is and how they work. So property deeds are legal documents used in real estate that transfer ownership, actually. The ownership of the real property from a grantor or a seller. So as I use those terms, I may say seller or grantor depending on where I am in this episode. I just want you to know that those are actually the same person or the same player in the real estate transaction. The grantor is the same as the seller, and they are actually documenting the fact in a deed, property deed, that they are transferring the ownership of that from the seller or the grantor to the buyer or the grantee. So as I go through the rest of the material that I have prepared for you, if you hear me say the term grantee, you mean that you just know that that's the buyer. And so that's what a property deed is. It's just legal documents that, you know, are used in real estate to transfer ownership of the real property from a grantor or seller to a grantee or buyer. Real property is land or anything attached to the land. So if you have a home on, say, an acre lot and you build a barn on the lot, that barn is also considered real property and is attached to the land, and so it would be sold, you know, or given deeded with the rest of the real property unless your deed specifically states otherwise, and we'll talk about that in a future episode. Roads can also be considered things that are transferred as a part of a deed. Sometimes you have these lovely estates that have multiple homes on them, and so they build roads in and around the property so that you can access those different buildings. And so those roads would also be things that could be awarded or given, transferred, I should say, as a part of a property deed. And so for a deed to be legally operative or valid, I should say, there are certain things that the deed must have in order for that to happen. It must include, more important than anything else, a specific property address or legal description of the property. It could use, like I said, a 911 address. You could use a parcel number. You could use a legal description. You can use meets and bounds, whatever your specific area deems, you know, acceptable as according to their state law. You put that information on the deed, and so that the property can be identified in the future if there's ever a dispute about who owns what. And so that is the main thing that it needs in order to be legal. And like I said, it must also include the identification of the person who is selling the property or giving up their interest in it, and the person who is receiving that interest, or the person that the real property is being granted to. More specifically, deeds fall under a number of categories. So there are different types of deeds that you can acquire when you're looking to buy real estate, or if it's willed to you or what have you. And the seller would be giving you a certain type of deed, or the transfer of ownership would come, and it's usually kind of consistent. So if you have a general warranty deed right now on a property, then you would convey or give to the person who is acquiring the property that same sort of deed. But we're going to go through here, and I'm going to give you some quick definitions of what the different types of deeds could be, and we'll talk a little bit about those. And like I said before, I'm getting these definitions that I'm about to put up on the screen and that I'm sharing with you and elaborating on with you from Investopedia.com, but there are other wonderful sites that you can go to find this type of information. You can go to your local government sites, the real estate commissions in your areas. Most real estate commissions have a website where they'll share with you, the type of deeds that are most commonly used in your state. You can also go to sources and sites such as Bankrate, Realtor.com. You can go to the National Association of Realtors website and get this information, and just a plethora of other sources. Those are just some of the main ones that I'm throwing out at you right now that you can use for quick reference. So I'd like to start by sharing with you some of these types of deeds. And while, like I said before, each state has its own requirements, most deeds contain those first two things that I mentioned. They need to have those in order to be valid. Some other things that they need to include is this. So your instrument or your deed has to be completed in writing, because it is a legal document that needs to be turned in to your local city officials so that they can have a record of the ownership of the property and whose hands it went from, and then whose hands it's going to. So you cannot have a legal deed if it's not in writing. Most deeds are completed on pre-printed forms. There is no legal requirement that any specific form be used in most states, as long as the essential elements are included in the paperwork that you prepare. The grantor must have the legal capacity to transfer the property, and the grantee must be capable of receiving the grant of property. A person who is competent to make a valid contract is considered competent to be a grantee or a grantor. So basically, the two parties have to be of sound mind and be able to make a decision as it relates to contracts in the specific area that the property is being conveyed in or given in. So, for example, you would not be able to necessarily transfer ownership from someone who is 90 and of sound mind to someone who is 17 and is mentally incapacitated or has some, challenges in that area, because they are technically, not deemed able to decipher and understand contracts and legal documents, and therefore you cannot legally convey property to them. The grantor and the grantee must be identified in such a way as to be ascertainable. So usually the grantor and the grantee, they sign off on a deed in the presence of a notary or someone who can verify that the two people who actually showed up, the person who's giving away their interest or selling their interest or what have you, and the person that is receiving that interest or buying it are of sound mind, and that they are exactly who they say they are. The operative word in any deed is the word conveyance. Conveyance means to give or to bestow upon. So the word convey must be present in every type of deed and it must be done in such a way that it's very clear, so that you know exactly what's supposed to happen. this person who is giving away the property or selling the property or conveying the property, quitting their interest in it, needs to say specifically what they're doing. What specific property are they giving away? You know, what does it include? If there are other real things on the property that are attached to it, and so forth and so on. The deed must be signed by the grantor and grantors if the property is owned by more than one person. So if you're, a husband and wife and both of your names are on the deed, then you both have to sign the deed in order to give up your interest. If you're in a situation where you have someone that's an executor of an estate, that person who is the executor must sign off to express that they are aware that the property is being sold or given away or what have you, and then they must express that they know who that property is being given or sold to. The deed must be legally delivered to the grantee or someone that's acting on the grantee's behalf. So it's not enough for the grantor or the person who is giving their interest over to someone else to just sign the deed. It also has to be delivered to the person that is receiving it in order for it to be valid. So it just can't have the seller's signature on it, and the buyer has to also admit that they have received that paperwork. And like I said, it must be accepted by the grantee, and typically deeds are accepted by the grantee, but under certain circumstances, a grantee can, in fact, in certain situations, reject a deed. So if the grantee reads over the deed and there are things in there that should be conveyed, or that there are things that were discussed that should be conveyed as a part of the transfer that are not listed, they can reject for that. They can reject if if there's an issue with taxes or any number of things. So just know that both the grantor and the grantee have to be an acknowledgement that this instrument is there. They have to both have signed off on it. They have to be of sound mind. They also have to be very aware of the type of deed that they're getting and be in agreement with receiving that type of deed if they're the one that's getting the property conveyed to them. So we've kind of gone over what a property deed is, and so in general, and so now I'm going to speak to you about the specific types of warranty deeds so that you have that information as well. The most common type of warranty deed is the general warranty deed, and general warranty deeds offer the grantee or the person who is accepting the property the most protection. With this type of deed, the grantor makes a series of legally binding promises called covenants and warranties to the grantee and their heirs, and they are agreeing to protect the grantee against any prior claims or demands of all persons whomsoever in regards to that land being conveyed. The usual covenants for title included in a general warranty deed are as follows. The covenant of cession, meaning that the grantor warrants that they own the property and they have the legal right to convey it or give it under whatever terms to the new owner. The covenant against encumbrances, denoting that the grantor warrants that the property is free of liens and encumbrances except as specifically stated in the deed. So like I said, that's why it's very important for a person who is receiving a deed to read it to make sure that what they're being promised is actually what's written in the deed. The covenant of quiet enjoyment, indicating that the grantee will have quiet possession of the property and will not be disturbed because the grantor had a defective title. And the covenant of further assurance, which is the final one of the final covenants that's common in a general warranty deed, and that is where the grantor promises to deliver any document necessary to make the title good. So usually in the case of a general warranty deed, before that particular type of deed is conveyed, the buyer and the seller make arrangements to have a title search. Usually in the course of a typical real estate transaction where real estate agents are involved, the seller is the one who typically pays for a title search because it is his job to make sure that he's getting a free and clear title to the property. If there's liens such as mechanics liens or tax liens, any other type of lien, then homeowners associations, for example, they will place liens on properties. If those things are not cleared up, then a general warranty deed cannot be conveyed because there are issues with giving a free and clear title. Now, that doesn't mean that, you can never get a general warranty deed. Usually when it's things of that nature, taxes, HOA fees, things of that nature, if they're not too much, then those things can be cleaned up during the closing process, and the person who placed the lien can get any funds that are due to them, and then a general warranty deed can be conveyed. The next type of deed is a special warranty deed, and a special warranty deed is offers the next level of protection for someone who is being granted a deed. And a general warranty in a general warranty deed, the grantor promises to warrant and defend the title conveyed against the claims of all persons where the grantor of a special warranty deed that they receive the title to the property and that they have not done anything while holding the title to create a defect. So basically what they're saying with the general warranty deed is, I cannot confirm that before I took this property that there was not some other thing lingering that could come up later. What I am promising you is that, and since I have had the title or the deed to the property, that I have not created a situation where there could be further defects to the title or the deed and other things such as liens that have been added because of my actions. So that's what a general warranty deed states. In other words, the only defects that arose during the grantor's ownership of the property are what's warranted. Due to this limitation, the special warranty offers the grantee less protection than the general warranty deed does offer. Many purchasers of real estate will insist on a general warranty deed to protect against problems that could arise as a result of a special warranty deed. And sometimes you will get a special warranty deed if you, purchase properties in a tax sale or, something like that. And the people who are managing the property tax system, whether it's your property assessor or whomever, what they're saying is before we took this property or foreclosed on it due to, a lack of taxes, we cannot be sure, if there were any other liens prior to that because we didn't check. That's basically what they're saying. Now, you can always have a title search done on your own if you want, just to see if there's anything out there that happened prior to, and you would use a closing attorney or a title company to take care of that for you. And then they do have certain loopholes depending on where you are and how your state and your local government officials organize things that will, give you pretty much, a high level of protection with the special warranty deed, but in no case will you get the same level of protection with it that you get with the general warranty deed. The next deed that I'm about to discuss is one that is most commonly used to convey property if there is a situation where there's a clouded title, and what that means is that the history of the conveyance of the property is not clear. And so if that's the case, we generally in the real estate industry call it a clouded title. And a quitclaim deed is basically allowing a specific person to quit their individual interest in a property. It does not release the ownership of said property where someone else may have had equal and equitable interest. Does not release them from their ownership. So when you are accepting a quitclaim deed, you're basically getting what we call a non-warranty deed. And it offers you, like I said, the least amount of protection. This type of deed conveys whatever interest the grantor currently has in the property, if any. No warranties or promises regarding the quality of title are made. If the grantor has a good title, the quitclaim deed is essentially as effective as a general warranty deed. However, if the title contains a defect, then the grantee has no legal recourse against the grantor under the deed. The quitclaim deed is often used if the grantor is not sure of the status of the title, if it contains any defects, or if the grantor wants no liability under the title covenants. So I've run into several situations in my career, my business, where we've conveyed a quitclaim deed. One of the most recent instances was one where I had a client who was looking to sell a home, and she had several sisters. Her father had a family before he met her mother and started a family with her and those sisters. This woman that I was representing had no relationship with the prior family. So when the father passed away, his assets were split equitably amongst his living heirs, which would be those 3 daughters, and 2 of the daughters wanted nothing to do with the property. So it was hard to get them to convey their interest, and they in fact didn't do so. The seller, who was interested in buying the home that the father lived in, actually decided that he would just take the interest of the person that I was working with, and that's exactly what he did. And so he's taking it other steps, I'm sure, to try to get all of the interest conveyed to him. But at that particular time, he really just wanted to begin working on the property for himself so that he could generate some income from it. And the woman that I was working with really just wanted to move on from the property. So he paid her just for her portion of what we determined that the property would be worth, and then they went on with their lives and went their separate ways. The final thing that I wanted to talk about here is what I like to call special warrants or special purpose deeds. And special purpose deeds are frequently used in connection with the court proceedings and instances where the deed is from a person acting in some typical type of official capacity. So like I said, if you have an executor of an estate, if a property is foreclosed on and an asset manager needs to move a property for a bank or a lending institution, these are the times that you would use a special purpose deed. And just for the purposes of share with you some types of special purpose deeds, I will post a little screenshot that tells you some quick definitions, but tells you also what some types of those are. So some types of special purpose deeds are included on the next slide, but they are not limited to just these types. So know that there are more types out there, but these are the most common ones. So you have an administrator's deed, you have an executor's deed, which are 2 types that I just gave a brief synopsis of. You have a tax deed, you have a deed in lieu of foreclosure, and a deed of gift. And the deed of gift is one that's used to convey the title on real property that is given for no consideration or for no token value. So that means someone just gave you some property and you didn't have to do anything for it or pay anything for it. So like I said at the beginning of the program, I am also going to put up my contact information so that you can share with me if there are any specific topics that you want me to speak about on our show. And I hope by giving you this information today, I've helped you to stay safe in your real estate transaction as it relates to property deeds. With that being said, I'd like to thank you for joining me. My name is Kay Thompson, and this has been A Lesson in Real Estate. Until next time, take care of yourself and each other. Bye now.